Sir, I'm Guruprasad from Bangalore.
I would like to ask the other participants to please keep their mics on mute apart from the speakers and the moderator. If you have any questions, you can ask in the comment section. So please keep your mics muted during the entire session. Vijay sir, can you hear me?
I think he's on mute.
I can hear you, yes.
Now we can hear you.
Yeah. Yeah, Vijay sir, your mic is muted.
Yes, I have muted it myself.
Yeah, I just thought to welcome you to the webinar.
Thank you very much.
I'll be the moderator. Yes, sir.
It's a pleasure being here. Thank you.
Thank you. We're starting in a minute or two, sir.
Divyansh, as a household rule, I think when any other speaker is speaking, we'll keep ourselves muted. Would that be better?
Yes, sir. Yes, sir. Yes, sir.
Thank you.
Thank you, sir.
Shashank sir, good evening. I am Rajendra Pal Singh.
Good evening. Good evening.
Good evening, Tangri sir.
Good evening, Singh sir. Good to see you.
Good evening, Rajendra.
Good evening to all. I am Naresh Kumar, advocate from New Delhi.
Maybe just starting in a minute or two, just a second. Good afternoon, everyone. I'm Advocate Divyansh, Rathi, Managing Partner at Lexidem and Rathi. I would like to welcome our viewers and distinguished panelists to latestlaws.com, Law Joint and Indian Resolution Center's Lexidem webinar on emerging trends in arbitration, mediation, challenges and opportunities. Today, we are highly privileged to have with us as keynote speaker, Honorable Justice K.G. Balakrishnan, former Chief Justice of India. Welcome, sir. For the panel discussion, our distinguished panelists are Mr. Vijay Tangri, Advocate, Delhi High Court. Vijay sir has worked extensively in litigation, corporate advisory field, handling clients in the oil and gas, IT, banking, and manufacturing industry. Welcome, sir. Next, we have with us Mr. Shashank, Garg, partner Advani and Company. Shashank sir handles commercial litigation and arbitration verticals at Advani and Company. He is also panel lawyer at GAIL, Special Counsel for Hindustan Copper Limited, Delhi Development Authority. Sir often represents clients before arbitral tribunals in ad hoc and institutional arbitration under all leading institutional rules and also acts as arbitrator. We are highly privileged to have the panelists for the webinar, sir. Welcome, sir. The webinar is also being telecasted live on latestlaws.com's Facebook page and YouTube channel. There will be a question and answer session at the end of the webinar. Attendees can use the question facility available on their screen at the bottom of their screen for asking the questions that will be answered at the end of the webinar. Now I would like to ask Vijay sir to start his address for the webinar for today's topic.
Hello, everybody. I would like to start by thanking Latest Laws and Law Joint for organizing this webinar, because in times such as in which we are right now, where pretty much everybody is confined in their homes, webinar is the only way for us to connect. And this is a very good opportunity. Now, coming to the topic at hand. Did we know, at least I didn't know till today, that courts in some countries handle only 5% of the disputes that are out there. The reason for that is not because the disputes are not disputes, but because the courts just do not have the time to work on each and every dispute out there. Also, in countries such as ours, the backlog is so much that the courts cannot just work on all disputes. So the solution to this is setting up an effective and efficient alternate dispute resolution system. Now, there are two kinds of dispute resolution systems. One, which are dictative, where a third party is appointed by the parties at dispute, who applies his mind to the dispute at hand, identifies the issues, and then passes an order or an award, which is binding on both the parties. The next method of dispute resolution, which is very popular, is a facilitative mechanism, where the third party appointee applies his mind, identifies the issues, but only acts as a facilitator of communication between the two parties at dispute, helps them with the possible solutions that they may arrive at, but then leaves the decision making to the parties so that they can decide as per their needs and their timelines they need to work on. Now, arbitration is a very effective method of dispute resolution and a very important one. A good arbitration system can lead to better and bigger investments coming into the country, as that a good arbitration system would signify the ease of doing business in a country. Now, our arbitration system has stood the test of time, though there have been a lot of challenges from the very beginning. Some of the challenges, such as the quality of arbitrators and the number of arbitrators, etc., has been resolved over a period of time. Also, there was a major challenge at the beginning because most of the arbitrators were retired judges from the High Court and the Supreme Court. So the method of documentation from the courts sometimes crept into the arbitration system, but gradually that has been remedied. However, there are other challenges which are still there. And in my view, the most significant challenge that we are facing today in this arbitration system is the challenge of overlapping laws. For example, the MSME Act, which was created to facilitate the growth and survival of the micro and small medium enterprises. And the act essentially was intended to facilitate their growth and provide for easy and quick recoveries of the dues of the MSMEs. Though this act or the MSMEs as such do not provide a huge contribution to the turnover of the country in terms of numbers, but they do provide work opportunities and employment opportunities to millions and trillions of people. And that is why their survival is very important. Now, some of the key provisions of the MSME Act are like Section 15, which deals with and states that no payment term between an MSME and its trading partner shall exceed 45 days from the date of acceptance of the goods or services or the deemed acceptance of the goods or the services. Section 16 states that if the buyer of goods and services from an MSME defaults in the payments, he or she shall be liable not only for the amounts that are due, but also heavy penalties and fines. Section 17 states that if there is a dispute between an MSME and its trading partner, then the Facilitation Council constituted under the MSME Act shall undertake conciliations between the two parties and try and resolve the dispute. Section 18 provides that if the dispute cannot be resolved, then the parties shall be referred to arbitration of the Facilitation Council or some other independent institution which undertakes arbitration. Most critical provision is Section 24, which has led to a lot of controversies and questions, which states that any provision which is contrary to the provisions given in Section 15 to 23 of the MSME Act, then the MSME Act shall prevail over this provision. Now, what this has led to is that in cases where the MSME enterprise and its trading partner have contracts which contain arbitration agreements, then the issue arises whether the statutory provision of the MSME Act will prevail or the arbitration agreement between the parties will prevail. Now, there have been a lot of judgments on this topic, and so far it has not been clearly resolved as to what the answer is, though various courts have tried to interpret it in one way or the other. Some have stated that the MSME Act does not anywhere say that it is subject to a contract between the parties, etc. So therefore, it will prevail. In other cases, courts have held that the MSME Act also does not state that it shall be exclusive remedy for the parties. Therefore, the arbitration agreement between the parties will prevail. Finally, the Supreme Court has stepped in and given some guidance and said that both can prevail. However, the condition is that if either of the two parties approaches the MSME first or initiates arbitration first, then the other party would have to follow the same dispute resolution mechanism. So therefore, this is one of the challenges which the arbitration system is facing, and we look upon the Supreme Court and the other judicial bodies to help us resolve these kind of situations. Also, there was a situation in the year 2002 where an Australian company had entered into a joint venture with Coal India Limited. And after some time, they had a dispute over some payment obligations. And consequently, they both went to arbitration before the ICC, which is the International Committee for Commerce, Chamber of Commerce. And ICC issued an award in favor of the Australian company for about $4 billion, Australian dollars, sorry. Coal India was kind of taken aback by the judgment. However, the Australian company proceeded to approach the Delhi High Court for implementation of the award, and Coal India simultaneously approached the Calcutta High Court for setting aside the award under the Arbitration Act 1996. The issue over there which arose was, do Indian courts have jurisdiction over arbitration awards which have been passed at a foreign seat? The Calcutta High Court decided that yes, they do have jurisdiction and set aside the award. Following which, the Australian company had to approach the United Nations Commission on International Trade Laws, where the matter was discussed in great detail, and it was found that the decision of the judge was wrong, and the Australian company can approach the United Nations Council for International Trade under treaties to which India is signatory, where India is required to provide an efficient and effective system of dispute resolution. And that is where they decided and awarded the compensation to the supplying the services. The dues were cleared, were ordered to be cleared by the international body, though no extra compensation was awarded because the international United Nations International Citral understood that India is a unique country and the burden of the judicial cases is so much that they cannot decide each and every case within a definite span of time. And this case in particular was languishing in the Indian courts for almost 9 years. So these are the kind of challenges we are facing now. Though the initial challenges have been dealt with, but these kind of challenges continue to be posed to us. And the Supreme Court has a bunch of cases before it where it will finally decide on this issue, whether Indian courts have jurisdiction to intervene in awards passed at a foreign seat of arbitration. So essentially, the purpose of this talk today, from my perspective, was to inform and learn. Also, it is an effort to highlight and identify the challenges which are out there for us as lawyers to identify and overcome for our clients and for the betterment of the arbitration system. So I will conclude my talk with a small quote from the father of the nation, Mahatma Gandhi. I realized that the true function of a lawyer was to unite parties given as under. The lesson was indelibly burnt into me that a large part of the time during the 20 years of my practice as a lawyer was occupied in bringing about private compromises of hundreds of cases. I lost nothing, thereby not even money, certainly not my soul. Signed, Mahatma Gandhi. Thank you.
Thank you, Vijay sir, for your enriching and insightful words. I'm sure your views will enlighten and further help our viewers on today's topic. Now, I would like to invite Shashank sir to share his experience and views on today's topic. Shashank sir.
Thank you, Divyanshu. Thank you, Mr. Tangri, for sharing some very pertinent challenges that are being faced in the domestic sphere of arbitration. Today's topic that we're looking at is emerging trends in arbitration and mediation challenges and opportunities. So, looking at what challenges were being faced, and then we can talk about certain opportunities which have been created either by judicial mechanism or by amendments in law or through the efforts of various stakeholders. I think we would all agree, those who have practiced arbitration in the last 10, 15 years or have seen the growth of arbitration and its law in this country, that there were multiple challenges, especially the interventionist approach that was being frowned upon of Indian courts. Greater difficulty was that, every high court used to have a different view. There were so many conflicting views on various aspects of interpretation of sections of Arbitration Act. Then interfering with awards. Sorry, I think I was muted. Am I audible?
Yes, sir, you are audible. Yes.
Okay, perfect. So the interventionist approach was, I think, the biggest challenge that the country was facing, wherein every award was being interfered with, and that was not the problem. The problem was the essence of Arbitration Act was to resolve disputes in a timely manner, in a cost-effective manner. When I say cost-effective, it does not really mean that it would be cheap, but it would become cheap because of the time that you will save in getting the dispute resolved. because of this interventions in Section 34, the awards were taking time, sometimes 6 years, 7 years, 10 years for somebody to get a final relief from Supreme Court. And all of you would agree, the unfortunate thing with our system is that as far as PSUs or Government of India or any state entity is concerned, they usually mechanically appeal against all awards. I will give you a very interesting example. Without naming the PSU I used to represent, there was an award in our favor. All the claims of the claimant were rejected. We had not filed any counterclaim. The cost of arbitration was awarded in the favor of the relevant PSU. I received a letter from the concerned legal department asking for my opinion whether to challenge the award. So you can imagine an award which is fully in our favor. All claims have been dismissed. There is still a very mechanical way of seeking an opinion whether to challenge an award which is in our favor. So this is the harsh reality that government entities till date have not taken awards seriously. They still find a way to challenge these awards before various forums and try and delay. The silver lining is that after Balco, there was a change in the judicial approach. Our Supreme Court, Honorable High Courts, even practitioners of arbitration, Government of India, they all took various steps time and again to put us back into the world map of arbitration. We started following international best practices, amendments of 2015, amendments of 2019, bringing Schedule 4, bringing Schedule 5, bringing Schedule 7. All of these were very, very positive moves. For example, one of the greatest disadvantages or challenges of the earlier regime of arbitration used to be the exorbitant fee that was being charged by arbitrators. That was put to check by introducing Schedule 4. Now, increasingly, arbitrators are following Schedule 4, or even otherwise, courts, while sending references in Section 11, are making sure that the judgment says the arbitrator would be paid as per Schedule 4. So there is obviously now a predetermined fee. So the relevant parties can budget, when they get into a dispute, that what is the amount of money that they would be spending on arbitrators and any other institution that they would follow. Then Schedule 5 and 7, which were brought in to bring in more accountability. One issue that we were facing some years ago was there were some arbitrators who were titled as pocket arbitrators. One company would have an arbitrator to resolve hundreds of disputes. They will have template awards. They would just change the name of the party, sign and deliver awards within 15-20 days of the reference being made. It was happening in cases of builder-buyer agreements. It was happening in cases of NBFCs. And by the time an affected party would realize that there is an award against him or her, and they would seek legal advice, 120 days that are permitted under the Act to challenge an award would be over. So this was a huge challenge, which I think the legislature realized in due course, and Schedule 5 and 7 were introduced, which have increased the accountability of arbitrators. The disclosure that is now mandatory as per Schedule 6 also ensures that the arbitrators clarify the amount of arbitrations that they are doing, what is their prior experience, how much time do they have at hand, will they be able to finish an arbitration within the stipulated time period, which was also introduced in 2015, the timelines which have now been revised in 2019. So now we have a 12-month period, 6 months to complete the pleadings and 12 months thereafter. So bringing these amendments, initially, all of us as practitioners were very apprehensive. We were not sure if these amendments will really play an important role, or whether we will see a huge amount of defiance. And they were everybody thought these amendments were slightly ahead of their time and overzealous. But interestingly and surprisingly, everybody adopted to them in no time. We are seeing awards coming in the stipulated time period. We are now seeing arbitrators also with the greater accountability, fee schedule being followed. So I would say something that was rather a challenge in 2015 when these amendments were introduced. And I remember a lot of speakers in foreign countries in different conferences were very apprehensive that, India, is it a jurisdiction which can follow such a stringent discipline suddenly? From 0 to 100, suddenly you want arbitrators to finish awards within specified timelines, to follow fee schedules, to give detailed disclosure. Will this happen? Fortunately, everybody adopted to it. Our practitioners, our honorable arbitrators, everybody showed great enthusiasm and have put us back on the world map. See, enforcement of award also was a great issue of concern. A lot of foreign entities, more than domestic entities, frowned upon India as a seat because they thought that enforcing an award can be a very, very time-consuming affair. We have realized, although we are still not the fastest or the best in the world, but we are improving dramatically. There are judgments time and again from the Supreme Court, which is frowned upon any sort of frivolous resistance to enforce a foreign award. We have seen in Vijay Karya's judgment, 50 lakh cost was imposed in, creating such deterrence is now becoming a norm. So parties are now very careful not to file frivolous, challenges to enforcement of awards or even to challenge an award. Associated Builder judgment of Justice Nariman, followed by several high courts and again developed in other judgments of the Supreme Court, also narrowed down the scope of Section 34 in a very good way, in a very positive way. The same was followed in the amendments of the Act. So now we have a very, very robust arbitration ecosystem. We have been able to overcome, I would say, a majority of challenges in the last few years. I always say that the last decade, it can be termed as the renaissance of Indian arbitration regime because every stakeholder worked together, whether it was judiciary, whether it was honorable arbitrators, whether it was our legislature or practitioners. We all stood up to the challenge. We all agreed to join hands while making efforts to make India a jurisdiction which is considered a favorable arbitration and mediation jurisdiction. In mediation also, one would realize that although arbitration was fast-paced, a lot of development took place in no time. But even in the mediation world, I think some remarkable changes have been seen. Supreme Court has set up committees after committees which have looked into training of mediators, making mediation as one of the first choices in disputes which are favorable for mediation. We have also seen now a draft committee is working on a draft legislation, and soon there could be an act which would deal with mediation. And India being one of the first few signatories of Singapore Mediation Convention also shows that the level of enthusiasm with respect to mediation in the country. Of course, mediation will take a little longer than arbitration because we have, this is a country, culturally, we tend to fight. We like our day in court. We like to be told by an arbitrator or a judge what is right and wrong. So we're not really in the habit of resolving disputes through a mediator or a conciliator. That's just, I think, a cultural issue which sooner or later we will realize is putting us behind everybody else in the world. We need stakeholders, that is the legal heads of various companies, managing directors and CEOs of various companies, to let mediation come forward and take the leap of faith in mediation to resolve their commercial disputes, which could be in billions of dollars. Because if it doesn't get resolved, there is always a scope to go for arbitration, litigation, etc. I see the approach today is, even if Supreme Court or the High Court sends parties for mediation in a commercial dispute, the idea is just to get over with it. Quickly get a report from the mediator that no mediation settlement could have been arrived, so that they could resume their arbitration or litigation. That approach has to change. Make an honest effort, give mediation a good try, and maybe 50%, 40% of those disputes may be resolved through mediation. So These are some of the challenges that I have noticed in the arbitration and mediation space, and the opportunities are ever increasing with all foreign institutions coming into India. You would have realized all the great institutions of the world have been organizing conferences and seminars in India only because India is a very, very crucial seat for world of arbitration. The training of mediators and arbitrators has been increasingly and widely being accepted. So many institutes are providing best mediation training and arbitration training. Indian Arbitration Forum, CIR, etc. are some of the pioneering bodies which are locally available, which are giving these kind of trainings and guidance to prospective arbitrators and mediators. So I would call upon all of you to have hope in the opportunities in mediation and arbitration space, and follow the best practices that have been inculcated with great effort by all the relevant stakeholders. That's all for now. Thank you. Thank you.
Thank you, Shashank sir, for your insightful thoughts and enriching experience on today's topic. Now I would like to invite Honorable Justice K.G. Balakrishnan sir to give his keynote address on today's topic.
Distinguished panelists, I'm happy that one more chapter of legal learning has been initiated by this organization, and that too very vibrant, important subject, arbitration, mediation. Thinking of the present pandemic situation, all the courts are likely to be burdened with so many cases because the speed of justice system has been drastically reduced. So the judges of the High Court, judges of the Supreme Court are not able to dispose of as many cases as they were doing it early. 35, 40, 50 cases were daily disposed of by the Supreme Court, either as SLPs or any other hearing matters. Now it has come down. So because the availability of time and this the method is not very suitable for our justice system. Naturally, that there will be a backlog of large number of cases. Then we have to find out what is the method by which we can streamline the whole thing. So certainly the mediation, the arbitration and conciliation is one opening way. So we have to change to the best way possible. We have Unilateral Act in according to the Unilateral, in 1996 we passed the act. Then 2015 we amended, 2021 we amended the act. Not very drastically, but there were amendments for our purpose. So the various how the time constraints within a short time, how we can get a award pass. So we fix the time, fix the fees, everything we have arranged, and it was almost working well. And so many arbitration proceedings were going on in India. But now it has come to almost, so hearing matters are going on. The other matters are still, he has come to a standstill because the facilities are not sufficient to examination of witness or other things. So we have to find out methods by which to solve these problems. And I am sure we have to make it a point that the large number of cases are likely to be settled by mediation or arbitration method. So the system we should improve. The grounds of challenge of the award should be, now it is of course minimized under section 36. It is only very limited section against public policy, against the Indian law, is outside the contract, the arbitration clause. All these are very, very limited grounds are available. But our imagination of laws is galore, So we will find out how to make it within the grounds available under section 36. So that is also there. But the fraud or corruption, that is also in the 2021 Act, it is made possible that somebody should, and the proceedings, whether the proceedings and the award could be stayed, all these are the new areas which is to discuss, and the court has to come to very definite, Supreme Court has to come to definite conclusions. And the qualification of the arbitrator is also extensive. The advocates, chartered accountant, company secretary, officers with a engineering degree or 10 years experience or technical or scientific streams. All these are fixed in the Act itself, so that the parties cannot nominate or appoint somebody who is not conversant with these proceedings, the arbitration proceedings, or the persons of their choice cannot come as arbitrators. These are all good amendments. The arbitration, they have to be streamlined. But so far, we are not reached up to the international level of arbitration. All the matters are they sit together, they hear, and they within a short time, they decide the matter. That is something very unique, and we should have more and more arbitration centers. At the instance of the government of India, or at the instance of, then only we would be able to make a progress, an impact on it. This is an alternative dispute resolution mechanism. We should improve that quality, the content of that, and we should have the award at the earliest, and it should be, the people should, the litigants should say that here the award is at the least minimum challenge against the award. They should be. Then only it will work well. This is something which we have to consider it. Thank you. Thank you very much for inviting to this function.
Thank you, Lordship, for your words of wisdom on today's topic. Now we want to our question and answer session.
Was it audible?
My first question. We are moving now to question and answer session, Lordship. Question session.
Okay.
So my first question pertains to on Arbitration Council of India. So I would like to ask Shashank, what are your on the upcoming mission of Arbitration Council of India and how it will improve the arbitration practice in India? What views on
Yes. Thank you, Divyanshu. Thank you, Lordship, for a very stimulating address. Arbitration Council of India is, one of the crucial topics which I think I should have discussed while giving my address. But so when ACI was being introduced as a result of Sudhir Krishna's committee, again, like everything else, there were several questions, several apprehensions that what is Arbitration Council of India's role? Do we need a regulator to regulate arbitrators? Do we need a regulator to regulate arbitral institutions? Is there any need? What would is it another way of giving power to the to the executive to play a vital role in arbitral appointments? I think all of these doubts will be cleared if anybody goes through the Act itself, composition of Arbitration Council of India, its role, its functions, and its powers. Arbitration Council of India has widely been promoted by Honorable Law Minister, and also in various conferences. I heard Justice Indu Malhotra had taken a stand, clarifying several doubts on Schedule 8 as well as Arbitration Council of India. Taking cue from what was the discourse in all those discussions, I think it is very clear. The role of ACI is to only control the mushrooming of arbitral institutions. What ACI intends to do is to grade arbitral institutions who want to be graded. So to say that ICC, SIAC, will they require a grading from Arbitration Council of India? The answer is it's completely up to them. Because after you are being graded, you become a graded institution in the jurisdiction of a particular high court, which the high court will use while performing its role under section 11 to delegate the power of appointment, not power, but the role of appointment to that concerned institution. Now, whether foreign institutes like ICC, SIAC, LCIA would be interested in doing this free service, I don't think so. I think their interest is for the parties to choose rules under ICC, SIAC, LCIA India, because it's a commercial venture. Whether they would want Delhi High Court to send a case to SIAC to appoint an arbitrator, because it's in section 11, when we go and get an arbitrator appointed, there is only a court fee. There is no other fee that the court charges for you to appoint an arbitrator. Therefore, it would not be proper for any institute to charge any further fee on that appointment of arbitrator. So that's the only role I think the graded institute is likely to do. So the craze about getting graded and the foreign institution getting very apprehensive of ACI, I think all of these are apprehensions which should be completely done away with. And simple reading of the act will clarify that ACI does not intend to regulate. Now, it also has to perform a very important function, that is to promote ADR mechanism. If you see the concerned section, it talks about, I think it is 43D, if I'm not wrong. It talks about promotion of all the ADR mechanisms, arbitration, mediation, conciliation, negotiation, etc. However, when you look at the rules below that, it only focuses on arbitration. So for the time being, I think ACI's focus remains promoting arbitration by educating arbitrators, by educating practitioners of arbitration, by, as I said, by continuously following international best practices, etc. Now comes the question of when will we see the ACI functioning? I don't know the answer to that, because from my sources and my understanding, Government of India for last 2 years has been hunting for a chairperson for ACI, has been hunting to find a CEO for ACI. Similarly, they've been hunting to find a chairperson for New Delhi International Arbitration Center. They've been hunting to find a CEO for NDIAC, but government has not been able to finally resolve who will be the first chairperson of either of these two very critical and important institutions which were being created under the 2015 Amendment Act. So once these bodies, once the leader has been finalized, once the body comes into force in terms of its constitution, then we will see what functions it will perform. But I think the role will be a very, very positive role, and no upcoming or established arbitrator, no upcoming or established arbitral institution should be wary of Arbitration Council of India. It does not have any interfering role at all. Thank you, Divyansh.
Thank you so much, sir, for providing clarity on the role of Arbitration Council of India's future. My next question is for Vijay, sir. That Commercial Courts Act has provided for mandatory 3-month period for mediation. So I want to know his practical experience, that has it practically helped in resolving commercial disputes via mediation and without going to the courts for final decision on those disputes?
Yes, the Commercial Courts Act has provided a period of 3 months for mediation and efforts to resolve the issues, but it has had a mixed response. In some cases where the parties are looking forward to resolving the disputes amongst themselves, yes, it has worked out. In other cases where parties have not been able to differentiate between the positions and the actual interests and have just stuck to their original bargaining points, in those cases, we have had to go back to the courts.
Thank you, sir, for sharing your past experience. My next question is for Shashank, sir. Sir, in many webinars and earlier also, I have seen that many panelists have said that allowing of foreign advocates in the field of arbitration in India has been a controversial issue, and other countries have taken upon it, like Dubai and other countries are allowing foreign arbitrators. So they have grown as a seat, like London and Singapore. Dubai has come up like a good seat. So what are your views that is this something which is stopping India from as a hot seat for arbitration, or like what are your views on this topic?
So first to clarify, Divyanshu, there is absolutely no embargo for any foreign arbitrator to arbitrate in India. In fact, time and again, foreign arbitrators are coming to India to arbitrate. I have done arbitrations where PSUs were involved under ICC rules, under SIAC rules, even ad hoc, where the chairpersons have been foreign arbitrators. And now Supreme Court has in fact even clarified that 2 Indian parties can choose a foreign seat. So to that extent, we have developed our jurisdiction. So there is no question of foreign arbitrators not being allowed to arbitrate in India. The worry actually started from Schedule 8. When it was being introduced, it gave certain, eligibility criteria for arbitral institutes to empanel arbitrators. And that Schedule 8 had no discussion about foreign arbitrators. So foreign arbitrators suddenly thought that, they have to shut their shops and they are not welcome in India anymore. That again was clarified by the law minister, and in various addresses, Ministry of Law and Justice clarified that this Schedule 8 does not apply to foreign arbitrators. There is no question of eliminating the role of foreign arbitrators. They're as welcome as anybody else. Understand the reason now. See, what is arbitration? Arbitration is a mechanism where parties are paying to a person of trust, eminence, and knowledge to resolve their dispute. So the choice has to remain with the parties, whether they like somebody from India, whether they like somebody from Singapore, London, wherever, if they can afford the fee of the concerned arbitrators. And if the subject matter is such that, they require that sort of expertise. For example, if it is a maritime dispute, we may, with respect, we may not have had our honorable judges from Supreme Court and High Court who would have dealt with complex maritime disputes as lawyers or as judges, because there is not much maritime work in at least the northern part of the country. There could be apt arbitrators in Singapore, in London, in Dubai, where maritime arbitration is a very, very developed field of arbitration. So there is, I think, no difficulty for foreign arbitrators to come and arbitrate. There are bodies like COMBAR, Commercial Bar Association of UK, which has been coming to India for last 5 years with a lot of QCs and a lot of, renowned arbitrators who come into India and speak to respective parties who are promoting their work and saying that, if you have an arbitration in London or if you have an arbitration in any part of the Europe, instead of taking a senior counsel from India who could be really expensive, you could brief us. Or they're also talking about their expertise as an arbitrator. So I think, as I mentioned in my opening address also, that the world is looking at us. Everybody seems to be interested in India as a market. India is a huge market for disputes, sadly so. Therefore, the role of foreign practitioners and arbitrators, as far as arbitration is concerned, cannot be ignored. And as I have already said, at the cost of repeating myself, there is no embargo on that. The only embargo is, of course, we are still struggling to figure out a way where foreign law firms can come and establish their offices in India. And that is taking, we've been talking about it for almost 10 years. Every year we think it is going to happen. That hasn't happened. So that is different from arbitration. Arbitration, we have no such difficulty currently. Divyanshu, I think you're frozen. I will take this opportunity to answer a question that I saw on the chat window about MSME Act. Divyanshu, can you hear me?
Coming properly.
Can I quickly answer another question on the chat window?
Yes, sir, you can.
So I read a question from Mr. R.K. Gupta asking if the parties do not know, if one party does not know the other party is an MSME while entering into a contract, would still the MSME Act prevail? Answer is yes. It is for the employer to make those inquiries. It is for the employer to ensure when they do their vendor registration that they are aware of the MSME status of that entity. Not knowing at the time of the contract is no excuse. MSME Act will come into play. The only remedy, and which is still, a case pending before Delhi High Court, which I am appearing in, is that if the party was not an MSME at that point of time and has taken a registration subsequently. So whether registration is mandatory or not is also something which Delhi High Court has decided in Ramki's judgment, which is under challenge before the division bench. So presently, even registration is not mandatory if you follow the Delhi High Court's judgment of Ramki Enterprises. Just by your turnover, if you are an MSME, you will be considered as an MSME and all the benefits will come into play. Divyanshu, over to you. Mr. Singh, I think his video is frozen. Would you like to look at some of the questions and put it to his lordship or Mr. Tangri?
Yes, sir.
He's back.
Yes, sir. I'm now. I'm here. Sorry, sir. There was some, I think, internet issue. Sir, my also concern was foreign advocates. Like for them also, Dubai center has developed very well because they have allowed foreign advocates. So where all these things have probably due to contentious issue till the time is there in India for allowing foreign advocates and firms. I think so. The arbitration will be still a bit slow on the development phase. International arbitration, we can say, in India.
No, you're right. You're right. But fly in and fly out is still allowed. Foreign counsels can come in, argue and leave as far as arbitrations are concerned, not in courts. The moot point is who's going to afford. So we have very, very competent senior counsels available in India, and it is very sparingly seen that, a party, especially it happens when there is a foreign entity involved, that they may want to brief a QC from Singapore, from London to come in. But otherwise, our senior counsels are equally competent. Increasingly, of course, once the foreign law firms come into Indian jurisdiction, these things will become a trend. Right now, as I said, fly in and fly out is possible. It's not being used as widely as Dubai. That's correct.
Thank you, sir. My next question is for Vijay, sir. What are your views on acceptability of private mediation, sir? There have been like how
that is an option we need to examine seriously, because normally the mediation, the more the mediators, the more the number of people applying their minds to it, the better the results would be. I believe that. So private mediators should be encouraged, but definitely there should be some controls around the system so that the mediation doesn't go out of hand and cannot be manipulated or misused. But apart from that, I think more the number of mediators out there who are well qualified, well trained, the better it would be for the system as a whole.
I think so, sir, something like mediation council of should be developed on the lines of arbitration council of India.
That's right.
Have a better control over quality of mediation.
Yes, Divyansh, that would be a very good initiative if that was to take off.
Yes, sir. So my final question is for both the panels on their views in current times on online arbitration and mediation, like how has an experience been over the past year and how have been they have been handling their online arbitration cases. Vijay sir, you can start, then Shashank sir can follow. Online arbitration, which you have been probably handling mediation, what your experiences have been, please, sir.
Yeah, to be honest, online mediation has been effective, I think. And because people are kind of tied up in one place, nobody has any reasons to be going around or moving for other commitments. So it has been kind of good in that way. The lockdown has been good in that way. It has kept people focused and committed to the mediation, and we have not had too many disruptions. and everybody has joined on the calls. But yes.
Sorry, I thought you were concluding. My apologies.
No, I'm done.
Right. So, taking forward Mr. Tangri's response, before I answer, may I take the liberty of putting this question to His Lordship Justice Balakrishnan, because as an arbitrator, if we can hear from His Lordship's his experience, and then I will tie in my answer from that.
Definitely.
Sir, can you share your experience as an arbitrator in last 12, 16 months when everything has transformed completely into virtual mode? Sir, you're on mute.
Yes, sir, please unmute yourself, Lordship.
Arguments are fine. Some of the lawyers appearing for either parties were in Mumbai. They are arguing. And one lawyer who was in Los Angeles in America, he was arguing from there. And myself in Delhi, one in Noida, one in Ahmedabad. We were hearing, listening to the argument very carefully. It was working well, wonderfully well, all these arguments. But the examination of witness is not possible. In some of the cases, the examination of witnesses have to be done. So we should put the questions and the answer and to be recorded all the to sit together. So that is not possible. Arguments are fine. That is, the lawyers are comfortable. They very because of this internet and Wi-Fi connections, it is going on well. My colleagues also say they are. I'm only in very few matters, but my colleagues who are in so many matters, they are very busily engaged in this arbitration, and it is going on. Well, very, very fine.
Thank you,
Thank
Lordship.
you, sir. Thank you. So why I requested His Lordship's response was I will only be able to speak from from a practitioner's point of view. So in my experience, I think the greatest thing that we have all witnessed in the pandemic was adaptation of the virtual hearings by courts and by arbitrators. We all thought in the beginning that, our honorable arbitrators, being retired judges, may not be tech savvy, whether they will be comfortable to switch to a completely virtual mode. So was with various courts. But we saw in a span of 2 months, everybody somehow was able to manage the basics in technology. Everybody was able to adapt themselves to this new format of doing dispute resolution. And as Justice Balakrishnan said, that evidentiary hearing is still a point of contention where unless both the parties are comfortable and if the dispute is not very complex, we have done some evidentiary hearings also. But if one of the parties feels that it cannot be done on a virtual mode, they do not trust the other party at all, the atmosphere is such that the arbitrator feels that there are chances that witness may be prompted or could be held externally, then evidentiary hearings become a challenge. We haven't found a way out. I'll just share. I was asking Justice R.C. Lahoti, Honorable former Chief Justice of India, about his experience with respect to doing evidentiary hearings, and he shared that what he's adopting is a 2-camera view where the witness is visible and also a camera behind the witness so that his screen is visible. So, I mean, these are some small adjustments one can look at if one has to go through, go ahead with the evidentiary hearings. But all in all, I think virtual mode is here to stay. We were wasting a lot of time in procedural hearings, just to chalk out timelines, to decide on dates, to fix up fee schedule, etc. Parties were to meet. Honorable arbitrators were to reach a venue was to be booked. So many logistical things, so much of cost in doing something which was completely unproductive. I think after the pandemic is over, and I wish it is over soon, at least as far as these procedural hearings are concerned, the arbitrators and parties will continue on the virtual mode. And I think the success of this is visible, and as Justice Balakrishnan already shared, that everybody seemed to be happy with the virtual hearings. So we have saved a lot of time and money, and since everybody seems to be comfortable, there is no reason for us to discontinue the virtual mode of dispute resolution in future. And Divyansh, you are fully aware that you are running successfully a center which is providing these services, and you would have seen the amount of the kind of demand that you would have faced in last 12 months. So
80-90% has cross-examination online, sir. Our hearings have been like with stenographer and screen sharing of the text. 70 to 80% cross-examination online.
So service providers like IDRC and many others in the country, I think, have a vital role to play, and others may also have to upgrade their setups to have technology to enable these virtual hearings seamlessly and to go on very smoothly. Delhi International Arbitration Center, being part of the committee, I can say, was one of the first to adopt it immediately, and has been conducting the hearings on WebEx very successfully. So I think we have all learned. And just to conclude, I hope the pandemic is over and everybody is safe, but we all follow the positive things that we have learned during this pandemic, even in future. Thank you.
Thank you so much, Shashank sir, for sharing your views on this topic, answering the questions, all the panelists and keynote speaker for answering the questions so gracefully. I would like to thank all the panelists, Balakrishnan sir, Vijay sir, Shashank sir, for joining us for today's webinar, taking time out of their busy schedule. I would like to thank them on behalf of Law Joint IDR Latest Laws. To know more about Indian Dispute Resolution Center, viewers can visit the website of the IDRC.com or contact us at info@theidrc.com. I would like to thank the supporters of the webinar, Vivekananda Institute of Professional Studies, Shashank University, Northcap University, for their kind support. I would like to thank all our viewers and audience for joining today for the webinar. With this, I have to wrap up this session. Stay at home, stay safe. Thanks for joining, everyone. Thank you, Shashank sir. Thank you, Balakrishnan. Thank you, Vijay sir, for joining today.
Thank you, everybody.
Thank you, sir.